Dear job seekers, it's 2026. And yes, robots can do almost everything now. You say you want to work from home. I say you don't even need to show up at all. You work at a snail's pace, at double the cost, using quadruple the space. And then wonder why employers are rethinking the workforce. That's exactly why I created this podcast. Not to scare you, but to prepare you. Like and subscribe to learn more.
Before we start today's conversation, we want to ground this episode properly.
What we're discussing today is general information about employment obligations, enforcement processes, and worker responsibilities.
This is not legal advice, and it doesn't replace speaking with a lawyer, paralegal, accountant, or government authority about your specific situation.
Employment law depends heavily on facts, timing, documentation, and credibility, and laws can change.
With that context in mind, let's get into episode 4. Last episode, I said something that really resonated with listeners. When it comes to employment law, you still need awareness, documentation, timing, and realistic expectations about how enforcement works.
And today, we're finishing that thought.
Because knowing your rights without understanding your responsibilities is how people lose credibility fast.
Ontario employment law isn't a shield you hide behind. It's a framework you participate in.
So today, we're shifting the lens. From what employers owe you to what you owe them, the law, regulators, and the public.
Employment is not just a job, it's a legal relationship.
When you accept a position, you agree, implicitly and explicitly, to certain standards of conduct.
That includes honesty, performance, compliance, and professionalism.
And these obligations exist regardless of whether you work in an office, remotely, part-time, full-time, or on contract. At a baseline, employees are expected to do the job they were hired to do.
Show up when scheduled. Follow lawful instructions. Respect workplace policies.
Comply with Ontario employment law, health and safety law, human rights law, and tax law.
Your employer doesn't have to tolerate repeated breaches simply because you meant well.
Let's talk about resume misrepresentation, because this is where many people get blindsided.
If you lie about your education, certifications, work history, or experience, an employer can terminate you for cause.
Even years later.
Ontario courts have consistently held that resume fraud undermines the foundation of the employment relationship.
And no, performing well later doesn't erase the deception.
What if I exaggerated slightly on my resume, but I learned the job quickly?
Exaggeration versus fabrication matters, but intent matters more.
If the misrepresentation influenced the hiring decision, the employer may still have grounds to terminate.
Many people confuse unfair with illegal.
Ontario allows employers to terminate employment at any time.
The difference is whether notice or pay is required, not whether termination feels justified.
Termination for cause removes notice obligations. Termination without cause doesn't. Human rights law protects employees, but it also expects cooperation.
Employees must not harass coworkers, supervisors, customers, or the public.
They must engage honestly in accommodation processes.
Refusing reasonable accommodations or acting abusively can undermine your protections.
Let's talk about tax law because it quietly trips people up.
Employees are responsible for truthful income reporting.
Side work, remote cross-border work, misclassified contractor roles, these all carry risk.
If you knowingly misrepresent your status, that liability doesn't land on your employer.
We need to spend real time on this next topic, because it's one of the most misunderstood areas of termination for cause in Ontario.
Harassment and discrimination are not just HR issues. They are serious legal risks, and they are one of the clearest pathways to lawful termination for cause.
Ontario employers are required to maintain workplaces free from harassment and discrimination. That obligation comes from human rights law, occupational health and safety law, and internal workplace policies.
And employees are not exempt from responsibility just because they don't think they meant harm.
Harassment doesn't require yelling, threats, or physical contact.
It can be comments, jokes, teasing, repeated remarks that single someone out.
For example, making comments like, "Did your wife make your lunch today?" might sound harmless to the person saying it.
But that comment can be construed as gender-based or sexual harassment because it reinforces gender stereotypes and targets someone based on sex or marital roles.
Another example might be asking a coworker repeatedly when they plan to have children, or joking that someone is too emotional to handle pressure.
Even comments about age, disability, religion, accent, or family structure can cross the line, especially if they're repeated or unwelcome.
One of the biggest mistakes employees make is focusing on intent.
Ontario law focuses on impact.
You don't get a free pass because you didn't mean it that way.
If the comment creates a hostile, uncomfortable, or humiliating environment, it can still be harassment.
We also need to zoom out for a moment and connect this conversation to workplace safety more broadly, because harassment isn't just a human resources issue. It's a safety issue.
And that's where people are often surprised to see how things like harassment policies connect to frameworks they already know, like WHMIS.
WHMIS stands for Workplace Hazardous Materials Information System.
Most people associate it with chemicals, labels, safety data sheets, and training, and that's correct.
But at its core, WHMIS is about hazard identification, risk communication, and prevention of harm.
It's a system designed to reduce workplace injury and illness by identifying hazards early and putting controls in place.
Here's the connection people miss.
Not all workplace hazards are chemical or physical.
Psychological hazards, including harassment, bullying, and discrimination, are also recognized risks to worker health and safety.
Ontario's Occupational Health and Safety Framework increasingly recognizes that harm doesn't have to come from a substance to be real.
In safety systems, including WHMIS, hazards are managed through controls.
Controls can be physical, administrative, or procedural.
In the context of harassment, policies are a form of administrative control.
So are reporting procedures, training programs, investigation processes, and access controls.
Access control isn't just about locked doors or restricted areas.
It's also about who has access to whom, supervision structures, reporting lines, and boundaries.
Clear harassment policies tell workers how to report concerns safely and confidentially.
They create pathways to intervene before harm escalates, which is exactly what safety legislation is designed to do.
Just like failing to report a chemical spill increases risk, failing to report harassment allows harm to continue.
Employers can't correct hazards they don't know about.
And employees have a responsibility to use reporting mechanisms appropriately.
Silence doesn't protect you. Documentation does.
When employers investigate harassment complaints, they are fulfilling safety obligations, not overreacting.
And when employees ignore policies, refuse training, or retaliate after complaints, that becomes a compliance issue.
Which can lead to discipline, including termination for cause.
Because once a hazard is identified, ignoring controls is not neutral behavior.
WHMIS teaches one lesson very clearly.
Hazards must be identified, communicated, and controlled.
That applies to chemicals and to conduct.
Workplace safety isn't just about what's on the floor or in the air. It's also about how people treat each other.
Termination for cause doesn't require criminal behavior.
Serious harassment or repeated harassment after warnings can justify immediate dismissal.
That includes sexual harassment, discriminatory remarks, bullying, and retaliation after a complaint is made.
If an employer has clear policies, provides training, investigates complaints, and documents incidents, termination for cause is far more likely to be upheld.
Let's give some concrete examples.
Repeated jokes about a coworker's gender, sexuality, or appearance, even if framed as humor.
Mocking religious practices, dress, or cultural customs.
Dismissive comments about accommodations, such as calling someone lazy for needing modified duties.
Retaliating against someone who raised a harassment complaint, even subtly.
Any of these can escalate from discipline to termination if not corrected.
Ontario employers are required to have written harassment and violence policies.
Employees are expected to read them, follow them, and comply.
Saying, "I didn't know the policy," is rarely persuasive.
Especially if training was provided or policies were accessible.
Another misconception is that employers must always give multiple warnings.
They don't.
Serious harassment or discriminatory conduct can justify immediate termination, even without prior discipline.
Each case depends on severity, context, and evidence.
Here's where documentation matters for everyone.
Employers document complaints, investigations, witness statements, and outcomes.
Employees should document interactions, warnings, and training they receive.
Because once harassment allegations are substantiated, the consequences can be swift.
Workplace culture has changed.
Comments that were tolerated 20 years ago are not tolerated today.
That doesn't mean you can't speak freely. It means you need awareness.
Because harassment and discrimination are not just violations, they are termination-level risks.
The Ministry of Labor enforces legislation. It does not advocate for individuals.
Filing a complaint triggers an administrative review, not a personal crusade.
And the ministry expects cooperation, accuracy, and evidence.
You file a claim when your employer violates the Employment Standards Act.
That includes unpaid wages, overtime violations, vacation pay issues, illegal deductions, or reprisal.
You do not file a claim for personality conflicts or poor management.
Documentation is everything.
That includes pay stubs, time records, contracts, emails, schedules, and written policies.
Keep timelines. Dates matter.
Verbal claims without records are difficult to enforce.
What if my employer never gave me pay stubs? That itself can be a violation.
But you still need evidence, bank deposits, schedules, communications.
Once filed, the ministry reviews the claim for jurisdiction.
The employer is notified and given a chance to respond.
Officers assess credibility, consistency, and documentation.
Some claims proceed, others are dismissed.
Example 1. Unpaid overtime with detailed time logs and emails, strong claim.
Example 2. Verbal allegations with no records, weak claim.
The difference isn't fairness, it's proof.
Now let's talk about customers and the public.
If a customer harasses an employee, the employer has duties, but employees must report incidents properly.
One rude customer interaction doesn't automatically trigger ministry involvement.
What if my employer doesn't ban a customer who harassed me?
They must investigate and address safety.
But outcomes depend on severity, pattern, and documentation.
Employers handle discipline and workplace safety.
Police handle criminal conduct.
The ministry addresses systemic failures, not isolated incidents handled appropriately. Workplace rights don't exist in a vacuum.
They come with obligations to employers, regulators, and the public.
Awareness, documentation, timing, and realism matter.
If you ignore that, enforcement won't save you. That's why this podcast exists, not to scare you, but to prepare you.
That's all for today's episode. Thank you for listening.
Like, subscribe, and tune in next week for more episodes on working in Ontario.